Hi, everyone. Great to see so many people join us online. Welcome to this Mathys Squire webinar on plausibility at the EPO, exploring the legacy of dasatinib, which will be presented by Anna Gregson and Stephen Garner, UK and European patent attorneys at Mathys Squire. My name is Saba Ismail, BD exec at the firm, and I'm delighted to be your host for today. Without further ado, it's a great pleasure to introduce our presenters today, Anna Gregson, UK and European patent attorney. Anna has over 10 years experience specializing in strategic patent management, including drafting and prosecuting applications, as well as coordinating worldwide patent families. Anna works with a diverse range of clients from international corporations to public sector organizations. Our second speaker today is Stephen Garner, UK and European patent attorney, who's experienced in also drafting and prosecuting defending patents across the wide range of life sciences technologies. Stephen also manages the prosecution of a number of significant global patent and European SPC portfolios. So without further ado, let me just hand over.
Thank you very much, Saba. I hope everyone can hear me. Right, so what we're going to be talking to you about today is plausibility at the EPO, specifically looking at EPO case law, and really what has happened in the last 3 years or so since the 2 decisions of the EPO's Boards of Appeal in the dasatinib cases. And what we'll do is we'll very briefly set out the background to those cases, how they came about, and why they caused such shockwaves in the industry when the decisions were handed down. And then the main part of the presentation will be looking at what has happened next, how have those decisions been followed, and then looking to see what that tells us about changes in practice, and how we should be thinking about plausibility from this point forwards, both in drafting patents, patent applications, but also in prosecution and defense of patents as well. So very briefly, at the EPO, plausibility is a test which is applied when you're considering technical effects associated with an invention, where an effect is being raised in support of the patentability of the invention. This idea about, has the application made it at least plausible that that effect is actually achieved? And the idea is that you can only bring in additional evidence that wasn't in the patent application if that basic level of plausibility is provided. And the aim of this is to exclude speculative or overly broad patents from being granted. And as people who are joining us may very well know, this is particularly important under considerations of sufficiency of disclosure and also inventive step. And the difference is really a question of whether the technical effect in question is recited in the claim or not. And if it's recited in the claim, it's generally a question of sufficiency of disclosure, which is the question, can you carry out the invention across the scope of that claim without an undue burden? Does it actually work? Can you make it work? Whereas if the effect is not recited in the claim, but is relied upon as part of the advantage associated with the invention, then the question of plausibility is considered usually under the ground of inventive step. General principles of plausibility, it's been referred to as a threshold test, and generally it is seen as a relatively low bar, or it certainly was, I think, before the dasatinib decisions. And there was this sense that you needed something going beyond the level of speculation, but you didn't need a clear teaching that something was definitely going to work. That level of proof, if you like, was not required, but merely that the skilled person would imagine it might be possible. And one of the well-cited decisions, the EPO Board of Appeal decisions, T609 of 02, set out in some detail what the requirements of plausibility could be. And in deciding whether or not a technical effect is made plausible, the skilled person was able to rely on, of course, the patent document, technical information from their common general knowledge, and also possibly documents cited within the patent and referenced within the patent. So at the point where the dasatinib decisions were handed down, there was a sense, I think, that the standard for plausibility was fairly low and it was relatively easy to meet that standard. And I will now hand over to Anna, who will take you briefly through those two decisions and explain how they changed things.
Thank you, Stephen. So, a quick refresher on the two dasatinib decisions. So the first of these, T488 of 16, dealt with the concept of plausibility in the context of inventive step. And the claims at issue here were product claims. The application was filed with claims to a broad Marcuse formula. However, during the opposition appeal, those claims were replaced ultimately by a single claim directed to dasatinib per se. And it's important to remember that the application, whilst it did have some synthetic data for some compounds, including dasatinib, didn't have any functional data demonstrating the activity of any of those compounds. There was just some general statement that said that some compounds, without saying which, had been tested using some assays without saying which, and that some activity had been observed, but it didn't expand on that in any way. And instead, the patentee attempted to rely on post-filed evidence that dasatinib did indeed have the asserted activity, which wasn't in fact at issue at all. You know, dasatinib had been proven to work and was a blockbuster drug. It's just that evidence wasn't included in the application. And ultimately, the board declined to consider that post-filed evidence, holding that the information and disclosure within the application itself was not enough to render that technical effect plausible. And there are a couple of quotes from the board on the slide there for you, and I think those sum up why people were sort of concerned or worried in the aftermath of the decision, because it really does seem to be a requirement. The board is stating that there needs to be, at least in some circumstances, data in the application it's filed. And without meeting that requirement for plausibility, the post-filed data was not admitted, not considered, and so the problem was reformulated as something much less ambitious, merely providing an alternative, and that was deemed to be obvious. So if we turn to the second decision, here, plausibility was being considered in the context of sufficiency. And rather than a product per se claim, we have a claim to a medical indication. So dasatinib for treating CML, which is a particular type of cancer. And there were no data in the application as filed in relation to dasatinib, either in the context of it treating CML or in relation to the underlying mechanistic activity. However, the patent did include a statement to the effect that dasatinib had equivalence to a known treatment for CML, imatinib, which was known to have activity as an inhibitor of this particular kinase, and that was known to be effective in the treatment of CML. And so in this instance, the board held that by this analogy that had been included in the application as filed, the plausibility threshold had been met. This was a verifiable technical concept that could be tested and verified by a skilled person. And as a result, the post-published data that the patentee had introduced was admitted, was considered, and the claim to dasatinib for treating CML was held to be sufficiently disclosed. So why did people think that these two decisions had set the cat amongst the pigeons back at the tail end of 2017? And the consensus was, particularly following that first decision, T488 of 16, that there had been a raising of the bar, a raising of the threshold for plausibility, because the board had indicated that at least in certain circumstances, there would be a requirement for data in the applications filed. And that was contrasted with some of the earlier pre-dasatinib case laws, such as T609 of 02, which Stephen mentioned. And it was really quite shocking that a patent with such a narrow claim focused on a proven blockbuster drug could be knocked out for inventive steps on the basis of plausibility. And it made a lot of people reassess their filing strategies, because there's always this balance between needing to file early to avoid prior art that might be published, and the need to file later so that there is more data available. And previously, perhaps there has been a tendency to file sooner because the plausibility test was a low threshold to cross. Whereas, in fact, if you need some data, as suggested by dasatinib, then, do you need to then tip that balance towards later filing, so you don't find yourself with an insurmountable plausibility problem? And the other key point that people were concerned about was that in the later decision, the patentee was able to establish plausibility by analogy effectively. And although the board was at pains to point out that a technical teaching is not rendered implausible merely because it is not obvious, if you flip that, the question becomes, well, if you need to rely on prior art to render your invention plausible, does that same prior art also provide a pointer to or provide reasonable expectation of success and leave you open to an objection of obviousness? So those were the main concerns, and I will hand over to Stephen now to take you through where we've come since then.
Thank you very much. Okay, so as it happens, since then, certainly up to the day before yesterday, there are only 4 decisions from the EPO's Boards of Appeal which expressly cite either T488 of 16 or T950 of 13. And they're shown in this slide here. The 2 dasatinib decisions are at the bottom. The 4 other decisions are at the top, color-coded based on which of the earlier decisions they reference. The arrows show roughly the point when the decision was made at the start, and then at the end when that was then published online. And so you can see, surprisingly perhaps, given the waves which the dasatinib decisions made at the time, they've not found their way into a great many decisions over the last 3 years. Although I think anecdotally we are aware that they are mentioned in submissions, particularly by opponents during opposition proceedings at the EPO rather a lot. But interestingly, they don't find their way into the written decision from the Boards of Appeal as much. But looking now a little bit more at those 4 decisions, and that's what we'll be talking about for most of the rest of this seminar. What can we learn from those? Well, 2 of the decisions come from the same Board of Appeal that decided the dasatinib cases, 3301, under the chairmanship of Lindner. It's perhaps not surprising that that board would be very familiar with the dasatinib decisions and would cite them. There are 2 other boards, 3302 and 3307, who have also cited these decisions in their later reasoning. Both inventive step under Article 56 and sufficiency under Article 83 have been up for consideration in these decisions. And interestingly, at the moment, the outcomes are 50-50 for patents being allowed or maintained and patents being revoked. So, the dasatinib decisions are not the sort of magic bullet that I think perhaps opponents had thought they might be, and they're not the fatal stumbling block that patentees had worried that they would be. So let's turn to the first of those, the earliest of those decisions, which is 227 of 14, and look a little bit about what happened in that case. So here we have an invention relating to a formulation that contains a hormone, a particular surfactant, and a bacteriostatic agent, which is selected from phenol and cresol. Those are the three sort of key components here. The closest prior art was also a liquid formulation of a similar hormone, but which contained a different surfactant and no bacteriostatic agent. And the invention allegedly solved a problem of turbidity when a bacteriostatic agent was added to the prior art formulation. Turbidity, for those who are not familiar with the term, is an optical property, it's an optical characteristic of a liquid which measures the clarity. So the problem was you would add these particular bacteriostatic agents and the liquid formulations would turn cloudy, and that was not desirable. Now, in this case, the opponent argued that the patent didn't do enough to render this technical effect of avoiding turbidity as being plausible, and so they said that it was not possible for post-file data to be relied upon. However, the board in this case held that the 488 of 16 dasatinib reasoning did not apply, and that there was a technical teaching in the application, in the patent, which stated that the formulations containing the tween 20 surfactant were opalescent, were not clear, whereas the formulations with the claimed surfactant were not, that they didn't suffer from this problem of turbidity. And it explained that the problem was due to the presence of the prior art surfactant and the phenol or cresol. And it was held there that the technical information in the patent was enough to render the alleged technical effect as plausible. I think they were, again, taking a relatively low bar to that. It was a testable technical statement, and that was enough. And on that basis, they allowed the post-filed experimental evidence to be considered. That showed this comparative effect of a reduction in turbidity, and an inventive step was acknowledged. So that was the first of the four cases, which perhaps set the stage a little bit for what was then to come. And I'll hand back to Anna now to talk through the second of those four cases.
Thank you, Stephen. So the second of these cases is the first and in fact only decision to cite the second of the two dasatinib cases. And here, as in that second dasatinib case, the claims were directed to a medical indication. So a particular compound, a rapamycin derivative called everolimus, for use in treating a particular type of tumour and tumour invasiveness, the tumour being PNET. And plausibility was considered in the context of sufficiency. And interestingly, the board of its own in its own reasoning referred back to a pre-dasatinib piece of case law, the much cited T609 of 02. In the context of plausibility, the patentee referred only to two paragraphs within the specification, which they alleged described the results of an ongoing clinical study with two different types of cancer, one of which was equivalent to PNET, and which there had been results for at the effective filing date. But the board disagreed and said that these statements were merely hypothetical and instead just described a desired outcome, that if you were to treat patients with these particular types of cancer, you would hope to see a reduction in one of these, or in these parameters. And so on that basis, the board concluded that the patent didn't make the use of everolimus in the treatment of peanut plausible and refused to consider any post-filed evidence in that regard. The question was also asked, well, okay, if there isn't data in the application which renders that plausible, is there anything in the common general knowledge that would remedy that? But here, the patentee had made their lives very difficult for themselves because, and it's very understandable, they had their eyes firmly set on the question of obviousness and differentiating themselves and distancing themselves from the prior art. And so in their arguments, they had made numerous statements about how peanut is difficult to treat and how it isn't possible to predict based on the efficacy of a particular agent for one cancer that it would also be effective in treating peanut. And they have further argued that in fact everolimus was the first in its class, first mTOR inhibitor that had been demonstrated or proposed for treating peanut. And so they distanced themselves so far from the prior art that the board held that there was nothing in the common general knowledge that could rectify the lack of data in the application. And there's a quote from the board at the top of the slide here for you. And you can see that the board really feels that because there hadn't been a proven established relationship, either via data or in the common general knowledge, it was therefore imperative that the application provided some sort of technical evidence. And that in the absence of that, plausibility wasn't met. And so the claims were held to be insufficient, and all the auxiliary requests which had tried to define monotherapies or more precise indications also fell for the same reasons. Now, it's interesting that in this case, it was actually the patentee that brought up the second dasatinib decision, T950 of 13, to try and support their position, because in that case, as you'll remember, there was no data either. But the board wasn't persuaded by the argument and differentiated between the facts and the situation in the dasatinib case and in the present case, because although there were no data in that second dasatinib decision, there was this analogy statement that taught and provided a verifiable statement that dasatinib acted in treating CML in a similar way to a proven drug, imatinib, and that link was well established, and that well-established link or relationship was missing in the application, in the patent in suit. And so the patentees did their best. They referred to that dasatinib decision, but it ultimately didn't help them. So yes, the claims were held insufficient. And so I will hand you back over now to Stephen, who will take you through the last two decisions, which refer back to the first dasatinib case again.
Thank you. So decision number 3, 1322 of 17, is now directed to a sort of dosage regimen of a particular active ingredient for use in treating osteoporosis by administration as a single dose of a particular amount, 150 milligrams. In this case, the closest prior art was a daily dose of the same active agent for treating osteoporosis, either at a 2.5 or 5 milligram daily dose level. And the patentee, in support of these claims, asserted there was a technical effect of reduced bone fracture incidence. There was a benefit of fracture reduction if you give a large single dose over obviously the longer time periods than if you give it at a daily dose at a lower level. And the opponents challenged the plausibility of this technical effect. What was interesting in this case, perhaps a little like the previous case that Anna described, the patent had set out a position, clearly with obviousness in mind, of the unexpected nature of reducing fractures, the fracture reduction benefit on monthly administration of compounds of this type. And in terms of other technical statements, the patent did mention a clinical development program, but it didn't provide any details or any results of that. And in a sense, this case, the facts here are not dissimilar to some of the facts of the previous patent. Now, the board in this case took a fairly dim view of what the patentee was trying to do based on the limited disclosure in the patent. And they said, first of all, that results that were only known to the inventors cannot be considered when assessing plausibility. In other words, it has to actually be in the patent. It's not just good enough to say, you know, we've seen that this works or it's in progress. You actually need to provide those technical, verifiable statements. The board did acknowledge that clinical data is not always required. That's T609 of 02 again. But in this case, there was no additional explanation, mechanistic explanation, or common general knowledge which could bridge the gap. And you know that the second quote that you can see there, a mere statement that a certain effect arises. And they noted here that the conditions were not even reflected by the technical feature of the claim. And what they mean there is that the claim did not say a 1 monthly administration schedule, it just said a single dose. And the board went on to say, in the absence of supporting circumstances, does not render the achievement of that effect plausible. And so plausibility was denied, with the result, as you might imagine, that post-published data, the clinical trials data, could not be taken into account. Now, here, the patentee actually argued on the basis of T488 of 16, the first dasatinib decision, and they said that that case related to a huge Marcouche class of compounds, whereas in this case it was directed very specifically to a single compound. There was no reason to doubt the statements in the patent that it would work, and so it should be distinguished on that basis, and actually that sufficiency should be, that plausibility should be acknowledged on that basis. But actually the board said, even though you may identify a specific compound in a way that the dasatinib case did not specifically identify in relation to certain technical effects, in other respects, the facts of this case are even worse than 488 of 16, because there's no statement that clearly links the technical features of claim 1 to the alleged effect, and that statement cannot be found in the description. So in a sense, it was even more deficient than the facts that led to the negative decision in 488 of 16. You can see which way this is going, of course. Under inventive step, then, the objective technical problem was formulated in a rather unambitious way, and just providing a medicine having a dosing interval that goes beyond a daily administration. And even that, might have been found obvious on the basis of a sort of common general knowledge. But in this case, even more than that, in the art, was this concept of total dose, which is where you administer less frequently, but with a dose that is equivalent to the number of daily doses that you would have given over that time period. And obviously, prior art teaching a 5 milligram daily dose, to choose a monthly dose, about 30 days, which is 30 times higher than that, was not held to be an invention. So in this case, again, there was a fundamental lack of verifiable technical statements which could be relied upon for plausibility, and that was denied. So I'll move on now to the final case of these four, T184 of 16. And this case was given a distribution code C. It's the only one of the 4 cases to get that higher distribution code, which means it is distributed among the chairs of the boards of appeal. It denotes that there is something in this that the board that issued the decision felt was of some note. And we'll get to that sort of at the end of the decision. It was a classical pharmaceutical case. You have a Marcouche structure of a particular class of compounds, and then separate claims to the use of those compounds in treating medical indications based on an alleged inhibitory activity to sodium-dependent glucose transporters, and those conditions are diabetes and diabetes-related conditions. Here we have the opponents again asserting there is no evidence for that inhibition, for that activity, and there's no plausible technical effect. Post-filing evidence shouldn't be taken into account. What is, I think, noteworthy here is that the board, when looking initially at the question of sufficiency of disclosure, they acknowledged that the patent did not contain experimental evidence, but they said you need to consider the common general knowledge and also the prior art. And this perhaps goes a little bit further than many of the cases that came before it in terms of what the skilled person has to consider. Now, when looking at sufficiency and plausibility, they considered sort of 2 lines of case law that came before, whether there's prima facie serious doubts, sort of a teaching away, if you like, in the art, or any a priori reason why you would not be able to obtain that effect. And they came to the conclusion, on the basis of the facts in that case and the prior art of record, that there were no serious doubts or reasons to believe that it wouldn't be obtained. And then they looked to the prior art for some indication of plausibility that it might work. And here they looked to one of the prior art documents, D7, which disclosed inhibitors having a similar core structure to those that were claimed, and described their activity as inhibitors of SGLT2. And that, it was held, was enough to render the technical effect plausible, that they had some structural similarity with compounds of the art. Of course, the opponent said, no, this is a new family of compounds, so that's not enough. It doesn't tell you that anything falling within the scope of the claims actually works. And the board said, no, that doesn't raise prima facie serious doubts. The skilled person could see that it might work on the basis of this structural analogy, and that is enough. That's enough to discharge their burden of proof. That then allowed the patentee to bring in their post-filed data, and was enough for the board to acknowledge sufficiency of disclosure. The board then went on to look at inventive step, having found the claims to be sufficient, and they were dealing with a situation where we have a difference in one aryl substituent is the sort of distinguishing technical structural feature between the compounds of the closest prior art and those of the invention. The patentee had filed some data, which was a comparison of a number of the compounds of their invention with one of the compounds in the closest prior art document. And the board admitted and considered that evidence because they considered that the technical effect of inhibition of activity was rendered plausible, as they'd already described under sufficiency. And they considered that the post-file data demonstrated an improvement of the claimed compounds over those of the prior art, and they drew up the objective technical problem on that basis. It is the provision of improved inhibitors of SGLT2. And since there was no teaching or motivation in the art towards making that structural modification with the aim of increasing inhibitory activity, an inventive step could be acknowledged. The claims were not obvious. But I think there's a couple of interesting points in this inventive step section. Firstly, the plausibility which allowed the post-filed evidence to come in was considered at the same level as under sufficiency. It was, are the compounds active? Do they have some activity? Whereas when they then drew up the objective technical problem as part of the problem and solution approach that the skilled person is trying to solve, to decide whether or not the claims are obvious, this was a more ambitious technical problem than the one which arguably had been considered as a technical effect when plausibility was being assessed. So there's a difference there. And the second point that I think is really noteworthy here is the board in this case was took great pains to state that the criteria for plausibility and for obviousness are different. You'll recall from Anna's discussion earlier on that there was a real concern amongst practitioners and patentees that raising the bar of plausibility would bring it closer to the requirements for obviousness, and that gap could get so small that it would effectively be impossible to have an invention which was rendered plausible on the basis of a prior art disclosure and yet be inventive over that. And here the board is, I think, making a very clear statement. The criteria are different, and setting out why the requirements of plausibility are generally a sort of lower hurdle. And this is perhaps one of the reasons why it took that slightly higher distribution code and was considered worthy of sort of general dissemination amongst the boards of appeal. So those are the four cases. They don't stray too far from the dasatinib decisions or indeed from the previous case law, but I think they help to illustrate the way that the boards of appeal are dealing with these issues post-dasatinib, and I think they answer some questions and they raise some others. And I'll hand back over to Anna now to summarise and to take you through sort of where we are and where it goes from here.
Thank you, Stephen. So let's just summarise these four new cases that we've talked about this evening. There are a few key messages, I think, that we should take away from these decisions. So the first, and I think, if we think about what each of these decisions teaches us, I think the first, T227 of 14, it tells us, in line with the second dasatinib case, that a verifiable technical statement within the specification may be enough to render an asserted technical effect plausible, which is good to know, and it's good to have confirmation. But I think there is still the question of, okay, well, but is it necessary for that for the problem that we're solving to be something that is unknown in the art? If we think about the second decision, which cites the T950 of 13, so this is T1868 of 16, in the context of medical indications, I think that as it's clear from the board's reasoning here that if a mere reference to an ongoing trial or a future trial is not enough to make the outcome of that trial plausible, at least in cases where, and with good reason with a view to kind of establishing non-obviousness, you've tried hard to distinguish yourself and create clear blue water between the prior art and your invention. So, for example, if you've argued that the condition is hard to treat or that you're providing a drug which is first in its class, a mere statement that there are some desired outcomes is not enough. Even if there are in fact data, or there were in fact data at the effective filing date, you need to include some verifiable statement or the data to meet that threshold. I think that T1322 of 17 teaches us, and in this regard it's consistent with earlier pre-dasatinib case law, that it isn't results which are only in the hands of the inventors cannot be used to establish plausibility. The information needs to be available in the specification or to the public in other means of common general knowledge or in the prior art. You can't keep everything to yourself and then make an allegation that a result has been achieved and that would be plausible, even if there is nothing in the prior art that would give a skilled person reason to doubt that. So you can't sequester and hide your data away. And then I think that the last decision is for me the most interesting, and I think as Stephen has nicely explained here, really it's, well, okay, what are the different criteria for plausibility and non-obviousness, and how do we factor into those differences when prior art should be taken into account for assessing plausibility? So there are still some questions remaining, but we do get more information from these decisions which have followed the dasatinib cases. So yes, so some of the questions have been highlighted by the decisions have been answered, others are still open. When should we be using prior art to assess plausibility? If there are data that you can include in the application, if there is common general knowledge, a consensus teaching that you can rely on, then I think probably then it would, the safer approach and consistent with normal practice would be to not necessarily reference prior art documents in your specification. But if you have a weaker case, then maybe that's something that you should be considering. If you don't have those data, then you need to be thinking about analogy arguments and analogy statements that you can include to strengthen that position. I think another open question, as I hinted at, is what are the different requirements? What are the thresholds for plausibility versus reasonable expectation of success? How are those assessed? And really interestingly, I think, one, you have a technical effect that is being asserted and needs to be rendered plausible. Does that, or can that differ between sufficiency and inventive step? So as in T184 of 16, plausibility for Article 83 for sufficiency was acknowledged based on the technical effect of inhibitory activity, whereas when the technical problem was considered, the technical effect was improved activity, but the board didn't consider plausibility at that higher threshold. So what can we do? What have we learned and what can we do? We can't put our heads in the sand or under a pillow. We need to take these decisions into account in our day-to-day practice. And I think there are a few concrete practical practice points that we can use, both in relation to drafting and also for prosecution or during defence of patents, particularly pharmaceutical patents. From a drafting perspective, I think it is more important than ever to focus the mind on the fact that post-file data will only be considered if your application as filed renders a technical effect plausible. And so you need to balance very carefully the need for supporting that technical effect, whether that's with experimental data or a verifiable statement, with appropriate identification of prior art, so you can rely on those analogy arguments. If you have a clinical trial and there are data, don't just think that you can reference the clinical trial and that will get you home and dry. It won't. You need to include a verifiable statement or the data if possible, and that will help you reach the plausibility threshold. And I think for me, a real drafting take-home point is, yes, it's important to set out your stall on non-obviousness, but you need to take care, because if you have a weaker case for plausibility, you may be shooting yourself in the foot if you spend paragraphs and paragraphs in your specification explaining how different your invention is, and you don't have any verifiable technical effect in the application that's filed. And then when prosecuting, one thing that Stephen and I were kicking around when we were preparing the slides for this webinar is whether or not there might be cases when it would be better to focus on one claim category or another, because as we've talked about, product claims don't tend to include a technical effect, or not as often, in the claim language. So plausibility will be considered under inventive step, and that's a requirement for plausibility's effect across the scope. Whereas for a medical use claim, when the technical effect is included, then arguably you're looking at plausibility under sufficiency, and that's plausibility of the effect per se, which may be easier to establish. So, final slide. Has dasatinib raised the bar? And in my opinion, it's not the major change that people feared. It hasn't changed the direction. It hasn't made a massive step change in the requirement and the threshold for plausibility. You can see this by the fact that the cases have only been cited a handful of times since they were handed down. Pleasingly and reassuringly, we have confirmation, particularly in 184 of 16, that the thresholds for plausibility and reasonable expectation are not the same, although we still don't know exactly what the differences are. And therefore, you need to carefully consider the level of support you can include for your different claim categories in the application. If I have to sum it up, I think the overall direction of travel seems to be a gradual trend toward raising the bar, but it isn't perhaps the step change that people feared. And with that, I will hand over back to Saba to go through any questions or to ask any questions.
Thanks so much, Anna and Stephen, for that insightful presentation. We do have a couple of questions from the audience. Perhaps we can start with this question. In reference to T184 of 16, was this from the same board as the dasatinib decisions, given the attempt to clarify / draw a boundary around the plausibility effect?
Shall I take that one? I think that was probably my slide. The T184 of 16 decision came from the board 332, which was different to the board that that handed down the dasatinib decisions. Was T331, so a different board, a different chair. My feeling is that you know they were very aware of the concern generally around some of the questions that dasatinib had thrown up, and you know what they are trying to do is to put some more clarity around things. You know, so just as a sort of a general sense to try and be helpful in indicating where they think the case law should be going.
Brilliant. We've got also another question. Witness evidence of plausibility or lack of. Will the EPO pay any attention to it, give any weight to it? If so, when? And how do you bring the TBA round to the inclination to give weight to it?
Stephen, do you want me to get the ball rolling on this one?
You certainly can do. Yeah, go ahead.
Okay. Actually, there were some expert witness statements in the earliest of the dasatinib cases, and the board neatly summarised in that decision the established case law regarding sort of expert evidence and witness statements, and basically as is sort of standard, the board opines that the opinion of a highly skilled expert on how the disclosure of a document should be interpreted isn't necessarily reflective of the view of the notional skilled addressee, who is somebody who is of ordinary skill with knowledge of the common general knowledge. And so I think if you were talking about expert evidence like that, it would be difficult, given the preponderance of the Board of Appeal case law in relation to that, to get them to give weight to a statement from an expert saying that actually you would read this document and it would be plausible. I think you are looking for something which is either within the application as filed, be it data or a verifiable statement. If maybe the board would give more weight to signposting of things as verifiable statements, but I think just getting an expert opinion that this is plausible from this document because I say so and I'm an expert is going to be a tough sell.
Yeah, I absolutely agree with that. The way that the decision, that part of the decision is written in T488 of 16, I think the board was really shooting down the idea of using experts to explain to them how they should be reading the technical statements in the prior art. So I think they were quite quick to kind of close the door on that sort of argument, unfortunately. So I agree with Anna. I think that's going to be a really hard sell. There may be some circumstances, very particular circumstances, where expert declaration might be useful, but I think generally the boards probably aren't going to give that much weight.
Brilliant, thank you. There is another question. For overcoming objection under plausibility, could a sworn declaration by an inventor stating that the invention / particular aspect was plausible at the time the invention was made be helpful?
I think our previous answer may actually have addressed that. Anna, do you think there's anything else to say on that one?
No, I think we've covered it. I think that would be a tough sell to make.
Mm-hmm.
Brilliant. And I think we've got just one last question. Did the Board of Appeal in T184 of 16 get it right when they did not reassess plausibility under the inventor step after the more ambitious technical problem had been formulated?
That, I think, is a very interesting question. One is always cautious about saying whether or not a Board of Appeal got it right, because, of course, they always get it right. But I think this is a sort of policy question about, where do you draw the line? How high a bar is it right to put under plausibility, given that it's supposed to be this sort of low threshold test that just avoids completely speculative patent applications from being let through. And I think here I'd sort of note there is already well-established case law at the EPO in moving from a technical effect or a technical problem which is identified in the patent to a more ambitious objective technical problem, for example, if new closer prior art is found. And this idea of sort of reformulating the objective technical problem is already well established, that effectively you can do that as long as it doesn't change the character of the invention that sort of was originally set out. And so, you know, it feels to me that there is already a bit of a check and balance in the practice of the EPO on inventive step when you're reformulating the technical problem and you're looking at sort of new technical effects, which should help to avoid that going too far. And my personal feeling is that, you know, plausibility should not sort of be added into the mix, that you should be trying to render these additional technical effects plausible when really they only become relevant at a much later date in the event that new prior art is discovered. So I think it's arguable both ways. I think the policy could be argued sort of both ways. But in my view, the board in T184 of 16 did the right thing in keeping it at a relatively low threshold level, assessing whether some activity, some level of activity was plausible. And once they had found that it was, that ticked the boxes for sufficiency and inventive step. And, you know, setting up a more ambitious technical problem didn't affect that. So, yeah, I think in my view, the board in T184 of 16 did the right thing. But I think it would certainly be interesting to see whether that is followed or whether there's a change in practice as we move forwards.
Brilliant. Thank you, Stephen. Now, I promise this is the last question. We've got a question here asking, how confident would you feel to rely on prior art to support plausibility given the risk of jeopardizing inventive step?
I'm going to give a really lawyer-like answer here. It would depend on the case. I think it does make me nervous. But I think if you find yourself with a plausibility issue, then there isn't much you can do. If you can't establish plausibility based on the disclosure of the application as filed and the common general knowledge, then you're never going to even get on to consideration of obviousness. So if you have a weak hand as far as plausibility is concerned, then I think you need to give it serious consideration, because there's no point saving this wonderful argument for non-obviousness if you're just not going to get to that point.
Okay, brilliant. Thank you so much. I think this is the time where I wrap up, and I'd just like to say a huge thank you for everyone that joined in, and we hope that you found this session useful. I did get a question asking whether we'd be circulating the recording and PowerPoint presentation, and that is correct. We will be doing that. And lastly, to mention, you'll be redirected to a feedback form. We really love to hear your feedback about, you know, the topics that you'd love to hear about in the future, and how well you thought this webinar was. And then just to finally say, you have Stephen and Anna's email addresses on this slide. If there's any questions that that you'd like to discuss further or the topic, please feel free to email them directly. And this is just final to say thank you, and we hope to see you at a future webinar. Thanks, everyone.